Morning with 4 minutes delay, we start this international meeting on cities and international law. On behalf of our Dean, Fulvio Cortese, who is in Bologna today, I would like to welcome all the participants. I already welcomed them, actually, but I welcome them again. You are always welcome in Trento. Who came also from other countries to attend and to participate actively in this meeting on cities and international law. I would like to start by saying that this topic has been, I would say, has become very popular in recent times, although Janne Neyman and Helmut Haus, who are the authors of a wonderful book that has been awarded with the Collaborative Book Prize by ESIL in recent weeks, in recent days, started working on this topic together with other scholars and colleagues many years ago, I would say. Actually, Janne wrote also a book on a monograph on issues concerning the subjectivity and also other topics concerning regarding, I would say, the issues of subjectivity in international law, which of course is quite pertinent in today's meeting. But I was saying that cities and international law became popular because the topic as such is extremely important. First of all, because cities wanted to be more active on the international scenes in recent time, although this is not something really new. As we have said on several occasions, cities devoted a lot of attention to international affairs even at the beginning of last century. And also because cities have a lot of responsibilities beyond states, I would say, as regards international affairs in general. And this is extremely evident today when we talk about environment, when we talk about warfare, and there will be reports on this topic today, when we talk about the necessity of integrating the activity of international organizations with the activities of cities. Some of the cities, as we all know, today are even much more important or much more large than states, and their behavior in international relations is felt as something that could favor multilateralism and also the international, in general, I would say, international cooperation in many fields. And also, another important thing that, in my opinion, is extremely important to underline at the very beginning is the fact that cities are relevant not only for international law. And one of the great merits of the book that was edited by Janne and Helmut is exactly that of gathering contributions by different authors and also by people with different competences. You were very brave, I would say, because you were able to gather diverse people and diverse way of thinking in a wonderful book, the book I was referring to at the very beginning, that gives us, which is not, as it is said in the jury's decision of ESIL, it's not only they said it's not only something that is aimed at inquiring in specialized areas of law, but it has the ambition to be very relevant in many other fields. I refer to sociology, I refer to economics, I refer, of course, also to social studies in general. So I don't want to say too many things. I just wanted to introduce our meeting, and no, I cannot forget a very important thing, which is that in 2019, in this very hall, Francesco Francioni, who is today with us and will chair the first session, during a meeting of the Italian Yearbook of International Law Board of Editors, made the suggestion to have a focus in the 2020 volume of the Italian Yearbook of International Law on cities and international law. I must recall also, and Francesco surely agrees with me, that there was some perplexity on the part of some of our colleagues at the very beginning. Then, but you know, these perplexities lasted only the time of a coffee, because when Francesco explained to everybody with much better words than those I am using today, the relevance of cities in international law, everybody agrees that it was a great topic. And I am very proud and I'm content that we were able to devote our symposium with a bunch of articles, very important, I would say, articles on this topic in our 20th edition of the Italian Yearbook of International Law. This is it, and this is the wonderful book by, it's not a research handbook, it's much more than a research handbook on international law and cities, edited by Helmut and Janne. So with no further ado, I would ask Francesco to chair this meeting, and we will have a break at around 11:15 and then a second session at 11:30. Now, Francesco, the floor is yours.
Thank you very much, Pepe, and thanks for the organization of this interesting colloquium. We are in the same venue where we finally decided to have the last volume of the Italian Yearbook devoted to the topic that we are discussing today, cities and international law. When I was thinking about what to say this morning, just by way of introduction to the topic, I couldn't help to bring into our perspective the ideas of Giambattista Vico, the Neapolitan philosopher of the 17th century, who devised this idea of the cycles, the corsi and ricorsi in the pattern of history. And cities fits very well this pattern, because we have seen cities starting the origin of international law in the past, in the antiquity, with the polis, which are wrongly called city-states because they are not states at all, they are only cities. The medieval age with the communes in the Italian peninsula, the maritime republics, the northern cities of the Hansa League, and then, of course, the great cities, particularly Amsterdam, Bologna, which have given the imprint of scholarship and systematization. Of course, I need not to mention the role of Amsterdam, since, of course, Janne is here. But I would like also to remind the role of Bologna, because Bologna invented the idea of private international law. The statutists involved in addressing the interesting issue of what happens when a citizen of Bologna goes to Modena or to Venice, and he has to deal with his own succession, his estate, his contracts, or his property, etc. And they devised this interesting idea of the personal and the real statutes that today we may even ridiculize because they were so simplistic. But they were much more intelligent than the ideas that we developed later with the jurisdiction selecting rules, whereby we had to select a package of a whole legal system without understanding how the specific rules are going to regulate that particular relationship. So these ideas that was triumphant in the 19th century with Savigny and with Mancini, of course, then the statutist idea were taken back by the American Revolution of and this was all born in Bologna, and at a time when, of course, these people were involved in two incredibly difficult things: how to regulate the relationship between different citizens and how to make gold out of baser metals. You know, that was a scientist of the time. Yeah. Anyhow, this is the first, I would say, the corso, the cities. Then, of course, there is the ricorso, the triumphant march of the nation state. The nation state that has obliterated the cities and has taken the center stage in the development of international law. But then, of course, Vico, if he were still alive, would say, then there is another regression. We go back. And then, of course, we have the functionalism and the idea of international institutions that have to tame the state, because the state is bad because it's sovereign, and the international institutions are good because they pursue the common good. And of course, now we have again a regression because we don't like the international institutions any longer, and we are back to the cities. So here we are today talking about cities, but I think that we have to keep in mind how, you know, this wave, you know, there is a nouvelle vague and there is also an old vague that and I thought that Vico would have something to say about that. Anyhow, this is what I had to say by way of just a preliminary reflection on why this topic is so important, because of course it brings into our discussion not only the formal categories of international law, but the whole idea of what is international law and by whom it is made in a certain historical period. So we can immediately go into the matter of the topic, and I am very happy to give the floor to Jana Neiman. There is no need to introduce you because you have already been introduced as the originator of this important book, handbook. And Jana is a professor from the University of Amsterdam and at the Geneva Graduate Institute.
Oh, you're good. You're
did I manage to put everything
there?
there?
Name since a couple of months. So you're very up to date.
It was not easy, but I managed. You have the floor.
Well, you do better than I at this stage. Thank you so much, Francesco. Thank you for starting us off with this historical perspective, which I think is very important and also introduces, I think, the broader significance of the topic. But let me start first by thanking Pepe and Mirko for this kind invitation. It's really wonderful to celebrate both books, Pepe, that you mentioned, and examine together this morning the impact and the role of cities today on international law, international relations. My warmest congratulations, not just to the two of you and to the editors, but also to the authors who contributed to the Italian yearbook. I really enjoyed reading all the papers, and Christine is here, and Riccardo is here, and Francesco is here, and also the others who may be online joining us today. So as Francesco has just said, through your historical perspective, but also written in your contribution in the yearbook, there surely is a rise in scholarly interest in cities and international law. But as you also pointed out, in reality, there has always been a dominant role for cities in international law. And I thought I should actually quote you a dominant role in the development and implementation of international law. And yet there seems to be a general agreement that, to cite Pepe, the role of cities and transnational city networks in international law and international relations has significantly increased. And you state, Pepe, even the most skeptical and positivist international lawyer cannot ignore that something new is happening, and the issue cannot be underestimated. I think you mean the issue of cities and international law, but I think also the issue of the Italian yearbook cannot be underestimated. In a way, I think the fact that an institute like the Italian yearbook and the prize you just mentioned of the European Society for the edited volume, to which Mirko also contributed and others, recognizes that the field is no longer something out there, strange, exotic. Helmut and I used to joke about it. It's something crazy. International lawyers look at you. Are you okay? When you want to write on cities and international law. I think the volumes and the recognition at this stage shows that. And that's why I called my remarks, only a few remarks, don't be worried, out of the margins. I think there is a little subfield now which is part of international legal scholarship more generally, and invites our attention. So there has been a real outburst, and yet, to stay with Pepe's words, what this something new, as you call it, implies for international law surely is stuff for further discussion, and I'm sure we won't be finished at 1 o'clock today. So after a real outburst of scholarly publications, and it's not just this one, there are PhD theses, there is a book by Anush, there are many more than just the two we remark today. This symposium allows us, I would say, to take stock of what we can confidently call a new subfield within the discipline of international law. And so I was working with a nice acronym, Cities and International Law Scholarship, CILS, to mark the fact that this topic now has traction. So I take the opportunity today in my 10-12 minutes to raise the question, what then is the state of this new subfield in international legal scholarship? And obviously this is a huge question, which is impossible to answer. And I only want to, I hope you allow me to make 3 observations on this state of cities and international law scholarship. And this is not in the least inspired by the papers in the Italian yearbook. 3 remarks or observations of strands in the scholarship that we may discern and we may wish to develop. So first, research seems to have to move from whether to how cities transform international law and its legal categories. And I stay a bit more at Pepe's piece, while Pepe in his chapter emphasizes, Professor Nessi, I should probably say in Italian, I'm not in Amsterdam, so custom. In his chapter emphasizes the question whether the growing role of cities in international law transforms international law. I would argue, as Helmut and I have done in the introduction of the research handbook, that it is time for CILS to examine further how cities' engagement with international law challenges both traditional international legal categories and the understanding or concept of international law itself. While there is some general agreement that the role of cities and their transnational networks has increased, there surely is no agreement on what this means in terms of international legal status. Do cities as international agents or actors have international legal personality? Addressed as such, legal subjectivity of cities is approached as a rather formal legal predicate bestowed upon an agent by international law. When taking such a formal positivist perspective, allowing cities to have legal status and legal subjectivity in international law would entail a move away from the view of states as practically, basically, the exclusive legal persons in international law, and in any case would mean a disruption of the system or weaken, I think you call it, the system, and create an untenable situation. So to put it really clearly. So visibility as state organ and object of international law, yes, but international legal personality, no. I appreciate Professor Nesi's argument and his point that transnational city networks come closer to the more established category of international non-governmental organizations, and as such, to established practices of participation in international law. Personally, I've taken a somewhat different approach to the question of international legal personality of cities in a book I think you're familiar with, that Milos Vec, among others, edited. And I've wondered what it means when cities as such, not so much as state organ, internalize international law on their own accord, when cities self-identify with and subject themselves to international law, when they consider international norms as relevant to their local and global norm creation and conduct. It is an approach that takes the agent rather than the formal system as a starting point, and that goes to the classical question, how is an international legal person created? From the outside, from the inside? For me, examining the city as an agent in international law invites us to reflect on what international legal subjectivity is and what international law is today. The challenge to rethink the concept of international law itself then also invites us to rethink our set of legal categories. And some of that you see definitely authors in the book, in the research handbook, also do. And we're very grateful to our authors that made this collaborative book such an interesting one, not in the least also with the visibility, invisibility chapter Mirko wrote. But in this case, before I go to my second point, which will be shorter, and my third point even more short, even shorter, so no worries. But I think this rethinking and thinking about possible new legal categories to shape the legal existence of cities is also very clearly in the Italian yearbook with Lisinski's, for instance, in all, but also there, the idea of can our legal categories suffice and how should we rethink international law? So I think that is a development within scholarship that will continue and probably even enhance or increase. Secondly, cities and international law scholarship has reached a stage of more critical thinking. And here I do not just mean the critical engagement of the more formalist, positivist legal scholars as just discussed, but critical thinking about the implications of the increasing role of cities in international law. That is, the politics of cities' engagement with international law will increasingly receive, in my view, or need to receive our scholarly attention. Initially, we saw generally a favorable approach to the participation of cities in international law and global governance, considering it as an opportunity to remedy the democratic deficit of international law and global governance. And I see Ricardo sort of so and I have the same sort of hope, and it is true that many of us were and are intrigued by how cities started to use international law to correct what we understand as failures of national governments, most notably in the areas of climate change, migration, and human rights law. Among mayors and local governments, variations of when nations talk, cities act still circulate. And that goes to that audacity of hope. However, we only need to think of cities calling on their right to freedom of expression and defending freedom of religion and family life to legitimize, for example, just one example, LGBT-free cities, to realize that the city as a democratic representative defending the rule of law is a more problematic image than perhaps we initially thought. The rise of illiberal democracy, fault lines in society, the politics of cities' engagement with international law and human rights law, the city's engagement is much more complex than simply the instant democratization of international law and global governance. And you see again this, I noticed this angle, this problematique also in Daniel's chapter. There is the chapter on the rural and the urban divide. I hope to come back to that in a second, but it is, oh, I should change the page. It is a topic that's now really surfacing, that this critical thinking, this critical approach that is crucial in our thinking about cities and international law. And this means a firm scrutiny of who is in fact represented and who is given access to international lawmaking. Is it urban citizens? And then how does it relate to other citizens in the country? Or is it investors and multinational corporations? That is, those who steer the commodification and privatization of cities. And this again, wonderful paper I read with great interest, Kara's paper on the financialization of housing, which touches on these themes as well. So these are developments I've tried to capture with the notion of the private global city to explicate that in the global capitalist economy of today, still our urban public goods are often hijacked by private interest and finances. And a major question then could be, or is for me, which is not critical only, but can international law assist cities in pushing back these dynamics of hijacking? And pushing back and protect and promote public interests. Now, in view of the time, I'm going to speed up a little bit, but in other words, cities and international law scholarship has to ask critically who wins with the representation of what is sometimes called global cities at the international level: capital, industry, or citizens, democracy, commodification of the city. In short, what are the politics of the internationalization of the city? And how does this relate to the political or democratic legitimacy of international law? Very clear problematic at the heart, I think, of all your chapters in the yearbook. And maybe as the beginning of a dialogue with Francesco, the importance of the divide between urban and the rural, I guess, crucial, but also needs its critical reflections, as so much of inequality and poverty fault lines are within cities, as you also refer to in the mega cities. So third and final observation regarding where we might want to go with the SILS, with the cities and international law scholarship. At this stage of cities and international law scholarship, it is interesting how cities are related to multilateral discussions on multilateralism and what Guterres called inclusive network multilateralism. And the concerns raised earlier about how power dynamics are reproduced at the local level relate to my concerns with multi-stakeholderism, I think it's called, which points here to the inclusion of cities in norms creating and enforcing, and concerns I think we all share. Arguably, this has the potential to undermine legitimacy, not just strengthen it. But my final point in relation to taking up cities in this multi-stakeholder world is one more related and comes from a bit of a different angle, is related to responsibility and accountability. So if cities claim a seat at the table and claim, for example, independent implementation of international legal norms, independent creation of international legal norms, then at some point responsibility must be borne. Isn't it time to examine whether cities actually deliver also on their promises? Shouldn't we study city actions to hold them to account? When claiming rights, these come with duties. What about a public interest litigation against cities, not just against corporations? It's wild, perhaps, but it's just the uncomfortable feeling I have that there's a lot of talk of cities, not just nations, and we need to act. And this is something I see in Christine's and Ricardo's great papers on sustainability, the role of cities and their leadership in climate change law and the promotion of sustainability, looking for ways to make their role and their leadership role effective. So let me conclude with a reference to a chapter by Katja Kreutz in the research book, which I think was a difficult chapter to write. And she writes on responsibility in international law of cities, and not just as state organs. Obviously, that's the whole thing we've seen before. But she also tries to carve out some thoughts. What does this mean? Cities operating in international law on their own and on their own accord, and how can we then reflect on accountability and responsibility? And that to me seems to be a line of or a strand of research we might want to develop further as well. So with these sort of with this scholarly outburst, I think the little scholarly fields, cities and international law, is now out of the margins, and the city's increased role is well recognized, but we also need to stay critical and make sure that we keep asking the right questions. And in that sense, I want to end on again congratulating you on the yearbook. And for raising all these questions and be a critical partner in this field. So very much looking forward to all the presentations, and without further ado, I give you back the mic, and I'm going to listen. Thank you so much.
Thank you very much. Thanks a lot, Jana, for your introductory remarks. We appreciate your call for a more imaginative approach to framing this phenomenon of cities in international law within the traditional categories of international law, and also for addressing some of the consequences that, of course, this approach would entail. Some of them, of course, are problematic as well. Not just to mention what you touched, the topic you touched at the end of the responsibility. So we have very little time, so immediately move to the second speaker, Riccardo Pavoni. Riccardo is already known almost to all of you, but I would like to mention that he holds a doctorate from the University of Siena and from Oxford, a degree in international law, and he's a professor of international law in the law faculty of the University of Siena. Ricardo, you have the floor. You will speak, imagine, about cities and the sustainability. No, that's okay.
Okay. Thank you so much, Peppe, for organizing this meeting. Thank you so much, Mirko, for organizing this meeting. I think it's really a nice occasion to be here all together and to join our forces in a way, both the chief editors of the Research Handbook and some of the contributors to this volume of the Italian Yearbook, which was mostly devoted to cities and international law. As Peppe has already remembered the genesis of our engagement with this topic when we were here in Trento 3 years ago, and with this say visionary idea of Professor Francioni to devote a symposium on this, and all the reactions by our fellow colleagues that now we are making jokes about that, because indeed at the end of the day it was, I think, a pretty successful volume, and also our colleagues now are very happy with that. So this was really, I think, a very important project for us, something that also made us connect with other scholars working on this theme, which is fairly innovative, and it's really something which we should continue working on in a way or the other, as also Janne was recalling in her introductory remarks. When deciding how to, let's say, allocate the topics for this symposium, we decided to make this distinction between Christine Becker's paper about climate change and cities, which is, of course, pretty popular topic, of course. And I decided, and we decided that, but to devote another paper on, say, the engagement of cities with international environmental law and sustainable development more broadly as a whole, because that started from the realization that the engagement of cities with climate change law is a very significant aspect of the broader engagement of cities with international environmental law as a whole. An engagement which is now has a pretty let's say, long-standing pedigree, because already in the Brundtland report, very famous Brundtland report of 1987, there's a specific chapter about the urban challenge, and there is also some very important recommendations and also considerations about the increasingly important role of cities for the achievement of sustainable development. So starting from that landmark report, which everybody knows, the engagement of city increased in the following year, and I think this engagement with city with sustainable development processes has been really exponentially increasing in the following years. I don't want to say much about that historical trajectory because it's pretty well known. But let me just recall the importance of this movement, which arose in the aftermath of the 1992 UN Conference on Environment and Development. There was this key document, the Agenda 21, which was a document, of course, addressed to national governments, to states. But there were specific chapters devoted to sustainable cities and human settlements, and where there was this recommendations or this instruction given directly to cities and local governments to develop this so-called local Agenda 21. So this kind of local action plan adapting the global sustainable development targets to local needs and conditions. The local LA 21 movement is usually regarded as one of the main successes as a whole of the 1992 answer. Just to and I think this was, when I was researching this topic, was really significant to me to realize that we're always complaining about the failures of international environmental law, the weaknesses of international law. Then when it comes to what cities and local governments are doing in that area, we find out that this is indeed a success. the LA21 movement is usually considered one of the most dynamic and important follow-up processes of the 1992 UNCED. So I think this is very important to realize, because when Pepe recalls in his paper in the Italian yearbook that cities, when states only speak, cities act. I think that when you realize that this is indeed happening even in environmental law and in sustainable development law, I think this is very important. It's not only a sentence, but it's really finds evidence in practice about this. And I give other examples in my paper, for example, in other processes which are relevant to sustainable development. For example, in the emerging and increasingly important area of disaster law, cities play a fundamental role in the implementation of the international legal frameworks which are being developed in this area. I think it's important to recall that the Sendai framework for disaster risk reduction, which are so important because now they are the key legal framework at the international level in the area of disasters, were drafted also with the important contribution of cities, and cities are considered at length in that document. Of course, the cities are also contributing to the implementation of the Sendai framework. There is a major campaign, a major program, which is called Making Cities Resilient, which has been inaugurated in 2010, but it's now going on, which is, again, the UN Office for Disaster Risk Reduction considers the Making Cities Resilient, this campaign, this program, one of the most important successes in this area. So again, we find the key role of cities and local governments in the implementation of international environmental standards. So these are just a couple of examples taken from let's say, this historical trajectory. But I think nowadays the most important document and process is indeed the follow-up to the 2015 2030 Agenda for Sustainable Development adopted by the UN General Assembly, and of course the associated Sustainable Development Goals. Even there, we find another major success when it comes to the involvement and growing involvement of cities in sustainable development processes, because cities and their transnational city networks, I don't have time to speak in detail about these transnational city networks working in the area of sustainable development, but I do think that they are crucial, that I do think that they are a fundamental actor nowadays in the shaping and implementation of international environmental law and sustainable development standards. But I was saying that cities, together with their transnational city networks, actually sponsored and inaugurated this campaign to have an urban sustainable development goals in the 2030 agenda. And this campaign was very successful because indeed nowadays we have a specific sustainable development goal, SDG 11, entirely dedicated to sustainable cities and communities. So it's an important example of cities' influence on the shaping of the international agenda relevant to sustainable development. Then when it comes to SDG 11, making cities and communities sustainable, you can, let's say the abbreviation is Make Cities and Human Settlements Inclusive, Safe, Resilient, and Sustainable. So, of course, I read a nice paper by Helmut Haus together with Duplessis, commenting on this SDG 11. And I do agree that, of course, there is some overlapping between these objectives. Sometimes they are contradictory. There may be loopholes there. But I think that Helmut and Duplessis have overall a positive view about the inclusion of this SDG 11. They say that it's a powerful, that the 2030 agenda is a powerful document, that the overall SDG 11 is highly commendable, and I fully subscribe to this view. I think that the SDG 11 is indeed one of the most dynamic and tangible aspects of the Global Sustainable Development Agenda set in motion in 2015. And this is evidenced by the follow-up and implementation processes which are occurring in these very years and in these very days about the 2030 agenda. And there, you know, so the element arising from practice, which is most interesting to me, at least, is that cities and local governments are actively engaged in the implementation of the 2030 agenda as a whole, not only SDG 11, by means of these so-called voluntary local reviews, VLRs, which is local reports coming from cities where they detail the measures, the actions that they've taken to implement the 2030 agenda. Of course, they are imitating the title and format of the voluntary national review, which nation states have to carry out. But I think this is really another vibrant aspect arising from practice. I checked out the website a couple of days ago. There are now almost 100 voluntary local reviews arising from this method or from this aspect of the implementation of the 2030 agenda. Actually, I'd like to mention that the lead was taken actually by some, especially German and especially US cities in promoting this process of local reviews of the 2030 agenda. Actually, the very first regional government which drafted the report was the land of North Rhine-Westphalia back in 2016. Within 6 years now, we have almost 100. A key case, the case of the US, United States of America. This is very famous because we know that in the climate change area, cities, US cities are doing what the national government is not doing. And this happens also with the 2030 agenda as a whole. The United States of America is one of those states which is still to submit a voluntary national review to the UN, to the high-level political forum of the UN. Whereas many, an increasing number of US cities are submitting their own local reviews. I have just noted down the examples of New York City, Los Angeles, Pittsburgh, Orlando. They are submitting their local reviews despite the absence of the national government report. So this again telling when we want to draw some conclusions about cities' engagement in this area. I don't want to speak much further, so just a couple of words about what I do think that are the let's say the conceptual basis justifying this increasing and sustained involvement of cities and local governments in sustainable development and environmental law. Of course, here I'm not inventing anything new. In my paper, I examine and in rather detail the concepts of subsidiarity and the principle of public participation when it comes to, because they are usually, of course, for example, just to give an example of an author which is very famous in this area, Blanc was already talking about subsidiarity and public participation as the legal basis of justifying cities' increasing involvement in the shaping and implementation of international law as a whole. But I mean, my interest for these two bases was that when it comes to environmental law and sustainable development, of course, subsidiarity and public participation are very, very important, even more important than in many other areas of international law as a whole. Subsidiarity is a principle which can be very well can be used in a very effective way in our area, because it tells us that environmental law cannot be the same for whatever state, whatever region, whatever part of the planet. It must always be adapted to local needs and conditions. Subsidiarity may also justify the taking of more stringent measures by cities and local governments, and this is what happens for example, in the European Union in certain respects, but also in many other areas of the world. And it's worth noting that the principle of subsidiarity now is a general principle of EU law. Everybody knows that, but it was first introduced in the European treaties only with specific reference to the environmental policy of the European Union. So I think it acquires in this area a very, very prominent role to justify this increase in involvement of cities in this area. And the same goes for the principle of public participation. Principle of public participation, of course, is a key component of the human right to take part in the conduct of public affairs as a whole. But everybody knows that when it comes to environmental law, then the principle of public participation is crucial indeed. Is indeed one of the most fundamental aspects of modern international environmental law and of the modern law of sustainable development. I think here I'm fully subscribed to what many authors are saying in their writing. For example, Jorge Viñuales or Professor Francioni himself, they always underline this fundamental importance of the principle of public participation when it comes to sustainable development and environmental law. So, okay, what about cities and public participation? Of course, this is a very intimate link because, in my view, when it comes to the effective enforcement or the, let's say, is public participation meaningful? Is public participation significant? Does it affect international affairs? Well, I think it has more possibility to affect international affairs when it's organized at the local level, when it's organized by the institutions which are closest to the citizens, which, let's say, engage in this participatory democracy with respect to very concrete and tangible aspects of our everyday lives. For example, the management of waste, public transportation in cities, etc., etc. I think it's much more meaningful that public participation organized at the national level. And this is recognized by many authors, including authors in the area of constitutional law. They always say that, and they always justify, they're always usually in favor of a large measure of decentralization, public participation at the local level, etc., etc. So just to conclude very rapidly, I'm pretty enthusiastic about the role of cities and local governments in international environmental law and sustainable development processes. I fully subscribe and I completely agree with the general conclusions which the authors in the research handbook addressing this topic make in their own individual contributions. I think there's no difference between my views and what Du Plessis says, for example, in a paper, and what Yolène Line says in a paper, and what Louis Gauzet says in his paper. We are all in agreement that cities are very vibrant participant in international environmental law. Du Plessis uses this expression, which I also use. Cities are de facto participants in global environmental governance. I also say they are de facto independent agents of the international community when it comes to environmental law. And our overall conclusions are the same. They are a very important mode of environmental governance. That's what Yolène Line says in particular. Gauzet says that cities have become critical actors in the area of international environmental law. So we are really in agreement about this. I also conclude my paper with this optimistic view about the future of cities in international environmental law and sustainable development. Of course, there is that caveat, that proviso, which I'm not analyzing in my brief presentation, about the relationship between the rural and the urban, which Professor Francioni is analyzing in this paper, which I think also, especially in the wake of this powerful UN document, which has been adopted by the General Assembly back in 2018, the UN Declaration on the Rights of Peasants, which I think is a very powerful and important document also in this area, which Professor Francioni is talking about in his paper in the Italian Yearbook. And I think that I've also read a very, very instructive and telling paper by Gradoni and Pasquette in the last issue of the European Journal of International Law. This is really a paper that I recommend to make our own views and reflections about this connection and this relationship between cities and rural communities. So thank you so much for your attention.
Thank you, Riccardo, for this interesting presentation. You have traced the development of the role of cities from the Agenda 21 to today. The interesting part that you have dealt with in your paper concerning public participation, of course, raises a very interesting question. Why cities rather than the local communities? Why should we give a preference, a privilege to cities, where, of course, in view of sustainability, local communities may be much more the stakeholders or the title holders in terms of protection of the environment and development of sustainable methods. So this is something on which maybe we could center our discussion. Now, I think we have to move to the Zoom connection. Are we ready for that?
Sì, ci sono. Riuscite a sentirmi?
Ecco, sì, sembra che siamo connessi.
Io ci sono e vi sento perfettamente.
Ok. Allora, possiamo procedere ed è un piacere. I would like to introduce Professor Eliana Augusti, who unfortunately is not with us physically, but I see that she's virtually connected. And Eliana is a professor of legal history from Lecce, the Università del Salento. And I am happy to give you the floor, Eliana, please.
Thank you, Professor. First of all, I would like to thank Giuseppe Nesi and Mirko Sossai for their kind invitation, and Professor Francesco Francioni for the clear historical sketch of the preliminary reflections on cities and international dimension you offered us at the very beginning of the works. I'm really sorry to participate at the meeting just in this now obsolete COVID way, but as the organizers know, I am in Rome for an unquestionable meeting in the afternoon, so I had no other solution to arrive in time. I'm really sorry for this. Ubiquity is one of my priorities, but it is not yet my prerogative. So therefore, allow me to thank Helmut Aust and Jan Niemann for their precious work, and even more so for choosing such a complex, urgent and topical theme, cities and their emerging role in international law. The research handbook in the first part and with different approaches, let us review some cases that mark the legal history of cities from east to west at different latitudes and at different times. Valerie Hansen, Tobias Boystad, Susan Lepsius, Luigi Nuzzo, and again Mirko Sossai, Luisa Slava, George Hill, and Boris Bormann provide us with rich insights and different stories that inevitably enhance, and not only in the volume, the role that history and legal history in particular has in the international law debate on cities. But my task today is not to resume and summarize each of the appreciable contributions that appear in the volume, not to retrace a path already traced, but to try to provide some more ideas I hope useful to animate the debate. And in order to do this, I found very inspiring the reasoning, as also Janne underlined in her introduction, on the invisibility and the visibility of cities in international law and in the history of international law. First, about invisibility. As Mirko Sossai writes in his essays, one of the most popular historiographic theories focusing on European cities identifies urban centers as being in an inverse relationship with the modern state, in the sense that the history of the birth of the modern state is at one with the end of the city as an independent political entity. In this sense, cities progressively become invisible through the lens of international law, insofar as they are observed within the state. Similarly, Luigi Nuzzo underlines, as in the 19th century, cities lost their centrality to the advantage of the states, the only legitimate subjects of international law. If sovereignty was an exclusive prerogative of states, he writes, other territorial organizations enjoyed a limited degree of autonomy, and outside their borders, the relationship between sovereignty, territory, and subjects worked in a different way. But when have the cities been visible? When did cities become visible? So how can cities become more visible under international law today? Medieval cities, can you hear me?
Okay.
Yeah?
Yes, there are some interruptions, but I think you can go ahead.
Okay, thank you. I said medieval cities were shaped by emerging groups. Think of the role of bankers and merchants in the Middle Ages, or of the impact of the church and the institutions related to it. Cities were the fortress of territorial power. Their architectures were the representation of the established order and belonging to a recognized community, the premise of a community body. Cities were the undisputed protagonists of the political, social, and juridical scenario. Cities were visible. Cities will become equally visible again between the 18th and the 19th centuries, when they will become collectors of flows of men and women in search of a better future. As Saskia Sassen underlines, the Industrial Revolution will make cities the driving force behind the economic growth of state. The cities will participate, indeed, will be functional, instrumental to the process of a consolidation of the European powers. The rigid and impenetrable walls became open bridges, capable of allowing the ius transiti noxi of industrious foreigners eager to make their industriousness available to write the pages of the progress of Western civilization. The cities were the states and the states were the cities. Paris, Berlin, London were established as the places for the construction of a new diplomacy and the invention of the new science of international law. Cities were more than visible. And visibility becomes hyper-visibility, almost instrumental in the colonial experience. Cities become laboratories of progress, where every urban transformation is functional to the colonial project. It is a rewriting of space to recognize and control it. The metropolitan city and the colonial city are partially similar. The visible city is the recognizable city, finally civilized. But as the colonial city with its urban transformation approached the metropolitan city, the latter collapsed into the nation state. And we come to our time, to the opportunity that cities have to become architects of global change alongside the states. Cities and cities networks as a transnational network of local governments actively participate in the governance of global matters. We know development, human rights, migration, health governance, security governance, and transportation, guaranteeing all the advantages of what Bauman has defined a global approach. In this sense, we can see the gradual emancipation of cities from their traditional role as mere administrative subunits. As David Harvey said in 2012, cities become rebel. City networks were seeking to establish a forum for cities at the international level, which liberated them from the need to play only the role of observers in the world set up by states. But to better understand this rebellion and its outcomes, we need to come back to the 20th century, to the right to the city, which was the way experimented by a great philosopher of our time, like Henri Lefebvre, to combine cities and the law across the time. Lefebvre wrote Les droits à la ville in 1967. That right to the city was both a cry and a request. The cry was a response to the pain of the deep crisis in which life in the city was falling. The request was a real invitation to look that crisis in the face and promote an alternative that would give a new meaning and liveliness to urban life, making it less alienated and therefore also more conflictual and dialectical, open to becoming to encounters, both fearful and pleasant, constantly looking for inscrutable novelties. Outlining the right to the city, Lefebvre highlighted all the specificities of the city. The world crisis, which he was already experiencing at the end of the 1960s, was bringing out the new aspect of urban reality. What was scarcely evident before became clearer. Lefebvre revealed that was wrongly perceived, forcing us to reconsider the history of cities and knowledge about cities. Theoretical thought had conceived the city as an entity, as an organism among organisms. In the city, there was only a local effect, a projection of a national general history. A representation of this type, strongly Eurocentric, did not contemplate a theoretical knowledge of the city, nor did it contribute to achieving it. Only today, thanks to a growing attention that is taking shape on cities and their history, also from a global point of view, do we begin to grasp the specificity of the city and the urban phenomena, and to decline them in the various disciplinary contexts. The city has always had relations with the society as a whole, with its composition, functioning, with its constituent elements, with its history. The city, therefore, changes when the whole of a society changes. However, the transformation of the city are not the passive result of social globality and its changes. The city also depends on immediate relationships, on direct relationships between people and groups that make up society. Families, minorities, migrants, institutions, associations. But it is not reduced to the organization of these relationships. From this point of view, Lefebvre placed the city between two dimensions. Halfway between what he calls the proximate order, relations of individuals in more or less vast groups, more or less organized and structured in the relations between these groups, and the remote order, that of a society regulated by large and powerful institutions, global asset, international organizations, state, confessional institutions, by means of a more or less formalized juridical code or of a culture. In this sense, the city, Lefebvre wrote, is a mediation between mediations. As mediations, as a median subject, cities are not just at the receiving end of globalization or other remote orders. Cities appropriate, internalize, and then globalize to achieve their governmental and social goals, namely their autonomy from the interference of the remote order. Their reaction to interferences is participation. Cities participate as mediation between mediations. In this sense, the happy intuition of Arnulf Becker-Lorca and his Mestizo International Law works very well, promoting the representation of a counter-transfer. While they are affected by international norms and juridical and cultural codes, all the cities are also shaping development on the up level. Some of these developments are driven by individual cities, others by city networks, while still others see cooperation between cities, their networks, and international organizations. Leaving the comfort zone of our cities, of European cities, looking at post-colonial spaces, continuing to question ourselves on the right to the city, we come across extremely clarifying positions. We can see how Gyan Prakash, one of the most authoritative voices of subaltern studies, in 2008 pointed out how it would be necessary to think of the city, the Indian city, not as a laboratory of progress, or on the contrary, as a scenario of decay, but rather as a space for negotiating social differences, a place for encounters and experiences, a mediation between mediations. It will be clear then what Jürgen Osterhammel underlined too, if the state was a European invention, that is not true for the city. Urban cultures arouse independently. The city as a physical form and a mode of social life is not a transplant from Europe. And about the transversality of the paradigm, letting go of the reins of the Eurocentric approach, Giorgio Lapira in the last century read cities everywhere as a metaphor, a sort of a living document of a human civilization. They are not a museum, but an exemplification of the civil community and of the daily renegotiation of the community pact. Only in this way, only by accepting this interpretation of cities, will be possible to recover their social, historical, and cultural dimension. And it will be possible to face the challenges of a sudden globalization that is changing the schedule more and more urban, creating new spaces for relationships and undermining the old paradigms. From this point of view, as Francesco Bartolini recently noticed, the opportunity to insist on the concept of rebel cities and the rising cities, I think to Benjamin Barber and his work on dysfunctional nations, rising cities, such as on the so-called urban turn, fails, as well as the pushes towards emancipation of cities from their traditional role as a mere administrative subunits. To benefit from the promotion and the legitimate participation of the cities to international law, there is a need for a new transnational paradigm. In this direction, as Peter Clark in his Handbook of Cities in the World History demonstrated, and now the precious volume of Haus and Niemann confirmed, history can offer a necessary and irreplaceable support to international law reasonings. Thank you.
Thank you very much for this historical account. Very interesting, your insights on the role of cities as architects of the colonial empire and also as centers where their role is also changing in relation to the dynamic evolution of the society, the international society in general. I think it's quite interesting also what you said about the cities and international law is not a perspective that should be only European, because other cities, and in my brief remarks at the beginning of this colloquium, probably I failed to mention the role of cities in the African continent, especially the East Africa and the relations they had with the Asia. Yes, unfortunately, that however, is one of the failures of international law, because with decolonization, this very vibrant urban communities lost to the artificial insemination of the idea of the sovereign state with the disasters that entailed. So we should also think about this historical failure of a vital human aggregation and social aggregation that was obliterated by an artificial transplantation of the idea of sovereignty. This, of course, is all very interesting. Thank you for introducing this set of reflections. Now, what I don't know is we should have now a break. But we do have some time for taking, maybe we should take then 10 minutes. 10 minutes, if you agree, for some questions and remarks from the public, virtual public, and also the physical public. Okay. So anyone who's taking the floor, please also say your name.
Thank
Okay.
you. Tanaya Zar, UCL and visiting professor at University of Trento. Thank you very much for this really eye-opening event, but also research. I'm very new to this area, but you can see me as a very real enthusiast newcomer. I suppose listening to all the talks, a few questions arise. The first question has to do with how we define a city, especially if we look at, if we are considering accountability issues, this would become, but also of course, law creation, this becomes a real question, and whether this is something that should be, that is or should be determined by the state, which creates a problem with the rebellion that Professor Augusti then was referring to, or whether there are independent criteria for this, and there should be some self-identification in the process of identifying a city. And the second question I had was, Professor Neyman suggested that perhaps can we hold cities accountable? I wonder whether there is another question to be asked, whether do we need to hold cities accountable? And the final question that I think connects a little bit between Professor Pavoni's presentation and Professor Augusti's talk. You focused so much on implementation, and I wonder whether there is space to discuss issues of lawmaking, especially in the field of environmental law. That is a field that very often it is under attack as to whether the standards are customary international law or not. And of course, Professor Augusti was talking about the download and then upload. So downloading standards that are adopted by states and then implementing them, and so contributing to the upload towards custom. But I wonder whether we can see some law shaping process that does not involve a download from government decisions, but only an upload from cities through their networks, and a creation of, and how would that play with customary international law? Would that apply only to cities? Would it be customary international law? Thank you.
Okay, so here we have many questions that are addressed to the three of you. So shall we start with Professor Augusti? Do you have a response to these remarks? No? Okay, maybe. Okay.
I was looking in the chat. There seems maybe there's a question in the chat as well. I can see. Okay. Eliana.
Yeah, could you hear me?
Yes.
Okay. A very interesting question. Thank you. I think that personally, I think that the idea to imagine in a new law shaping process a control transfer could be a very interesting approach to have in the hypothesis to formulate a new role for cities in international law, because it's appreciable this double level, the down and the up. We can see it every day and we have also saw it during the pandemic period when the mayors of the cities had a great responsibility in the governance of the matters and all the problems that are connected to the matter. So I think also that we have, as Janne say, stay critical and to try to don't give simple answers, because we need to debate and we need to have a rich debate and multilateral and multidisciplinary debate. And I think that in this debate, a strategical role is necessary reserved to also the post-colonial and subaltern studies. I think that is necessary. Thank you.
Okay, so Jana, do you have any reaction?
Very quick, because
Okay.
You're right to protect the human right to coffee, I guess. No, very quickly, thank you so much. Of course, a very important question. I think it's undefinable in general, the city. my PhD student, Miha Machenko, who is the assistant editor of the research handbook. I want to mention his name at least once today. He did great work. He defended a PhD, I think last year, in which his definition and conceptualization of the city is much more sophisticated than I used it today, because in my remarks, I was assuming the local government when I was talking about what is happening to a city when the local government is engaging with international law in a way that it's self-constituting, self-identifying as a body of law, of norms that is relevant and constitutive of the city as an international legal person. So that's in brief an answer to the point on what is a city, which is indeed an important question to raise. Your point on accountability, well, it goes very much to the experience of cities gathering globally in huge international meetings. And what do I mean by that? Yes, nations talk, cities act. Yes, but cities talk a lot. And do they really always act? I've been to global Parliament of Mayor meetings, having the opportunity to speak there, to meet a lot of these networks, leaders. Yeah, it is in the area of climate change. I agree, it's impressive what's happening. And at the same time, you also need to stay critical and wonder. And that's where my sense of, okay, let's also look at what at accountability and responsibility obviously is the next step. But you ask, do we need to hold cities to account? Well, if cities claim power and claim shaping power and claim a position, then politics is there. Then we need to pay attention. So yes, I would say so. Just one comment, because I'm very grateful for the historical perspective you brought starting this morning. Eliana, thank you so much for a wonderful paper I really enjoyed. There is a lot of continuity in the remarks you made, in the remarks Eliana made, and yet Eliana is also right to, I think what is of interest to see what is the something new, to cite Pepe again, in what's happening today. And we've seen a continuity of empires, nation states, cities in different constellations throughout time. And what's there in terms of globalization, the global economy, but also globalization of diseases, that is different from maybe in the past, that is, relevant to our thinking of the change of the position of cities today. And also then, I mean, what's happening in China, Russia, where is empire thinking back in? So what I'm intrigued by what is particular also about these days that help us reflect on the changing role, or the fact that we are having an increased scholarly interest. More to say, but please, Ricardo, you're the one that
Okay,
it's the final word.
Yeah, just a few words, because actually what Dana was asking and is really complex issue. I think it's you cannot be just disposed of in 1 minute. But let's say that at a very general, at a very high level of generality, that of course the impact of cities and local governments on treaty making is more visible, because of course they are participants in some international negotiations. They are a part of the high level political forum on sustainable development. ICLEI, which is this very powerful transnational city network, local governments for sustainability is the full name, is actually an observer at the Rio Conventions. So it fully participates in all debates and meetings of, for example, the Convention on Biological Diversity or the UNFCCC. Of course, they have all the procedural rights which is possible to think of, with the exception of the right to vote. So they cannot vote. And that's, of course, a major limitation. When it comes to, but I think that they have a very significant indirect lawmaking function. When it comes to customary law, I think it's more complicated. There's also a very interesting paper within the research handbook written by Takashiba on this topic, which I read 1 year ago. So I must reread because I have forgotten his conclusions. But of course, I don't remember whether Michael Woods speaks about the role of subnational units of governments in the lawmaking process. I don't think there's anything in his reports about the possible role of local governments in the making of customary international law, and I think that could be taken as a gap, as a loophole, because well. They have, at least in that case, an indirect role in customary lawmaking, at least when they do not go against their own national government. Then in the particular case, I have a problem here. I think we must face a dilemma, because of course their position is against their own national government. So how do you reconcile that with the formal categories of international law? Then, of course, it's not the end of the story, because if this position by one local government is shared by thousands of local governments globally, and their position is pooled by their own transnational city network and affirmed at the international level in the relevant fora, then I think at least we may think of a more robust impact on the customary lawmaking process. But thank you for your question, and it's really certain that there is room for reflection about that.
So we would be very happy to take also other questions. Okay, there is one. Please identify yourself, or maybe if you want to come here, since you are there in a dark corner of the room and nobody sees you.
Right. But I think you can hear me anyway. So Elena Fasoli, associate professor at the University of Trento here. Since public participation was mentioned, of course, I had to, ask you something and point to the accountability aspect about cities. Well, sometimes, as Dana was pointing also in her question, sometimes there is no need, of course, to cities to be accountable, because it actually goes through the state. When the city is not allowing certain environmental information, which is not, for example, allowing certain public participation for the public and so on and so forth, it goes through the state. And the case, of course, I'm referring to the Compliance Committee of the Aarhus Convention, for example. So it goes in that direction, the classical, of course, Westphalian model, whereby we don't see those actors, cities and other non-state actors as being relevant, but still, of course, that's the approach. So it depends on the sector, it depends on the area. And sometimes you don't need, of course, to have this, accountability element, but because the mechanism is set in a way to go through the state first. In other areas, as you just mentioned, instead, we could argue and talk about the possibility to see a different type of responsibility or accountability for cities, not states, of course. Thanks. It is just a comment, of course.
Thank you. Thank you very much for your comment. Any reaction from the speakers? Maybe you, Jana.
Well, I'm tempted, though, the coffee. No, I understand, of course, the traditional mechanisms and the response there. But if you have like a city implement or taking for Batum a city, a convention, and which has happened with CEDAW, I now play with that example. And that city then develops a certain, in this case, it did develop an enforcement mechanism locally. But you can imagine that there are situations where cities take up an initiative, engage with international law, talk a lot about it. The state, the host state, is not involved. And you wonder, well, it's like with corporations, if you show off saying I'm doing this and that in terms of international law implementation, but you don't create a mechanism, yeah, I think citizens may be interested. And that's the kind of accountability I was referring to.
Yeah.
Sorry for the sort of this sort of short response, but
No,
in
there
respect
is,
of
if
time.
I may add, there is another aspect that is quite interesting, that the city may trigger the accountability of the state in some
As-
situations.
yeah, as well.
I would like to give you an example. There is a city in Turkey that is a World Heritage, which is a city that has been heavily damaged by the criminal activities of the Turkish government in bombarding the posts of the Kurds. And this city, of course, has been reacting in the sense of being the witness of the criminal action of the government in destroying a place that is of world importance recklessly. And this is a very important role that the city may have as the trigger of the responsibility of the state. Whether, of course, it worked in the case of Turkey or not, but that's another question. But so anyhow, thanks to everyone for the presentations, to Ian, to Ricardo, to Eliana, and at this point, I think we will go a break for a few minutes. And I don't know if we are in your hands, Pepe, for where to go. And thanks also for the interventions from the public, to Danae and to Elena. Thank you very much.